I welcome members to the 26th meeting in 2013 of the Delegated Powers and Law Reform Committee, and as ever ask members to switch off mobile phones. Agenda item 1 is a decision on taking business in private. It's proposed the committee takes items 5, 6 and 7 in private. Items 5 and 6 are on the committee's consideration of its draft reports on the delegated powers contained in the Children and Young People Scotland Bill and the Marriage and Civil Partnership Bill, respectively. Item 7 is consideration of a draft report outlining the work of the committee during the parliamentary year 2012-13. Does the committee agree to take those items in private, please?
Agree.
Thank you. Which brings us to agenda item 2, instruments subject to negative procedure. The Food Additives, Flavourings, Enzymes and Extraction Solvents, Scotland Regulations 2013, SSI 2013-266. Both Article 9.4 and 9.5 of EU Regulation 2065-2003, which are specified in Schedule 3 of the instrument, apply to both an authorised product and a derived smoke flavouring produced from an authorised product. The effect of being specified in the schedule is to make non-compliance with the provision an offence. The description of the subject matter in Article 9.4 refers to both regulated substances, but the description of the subject matter of Article 9.5 refers only to authorised products. The committee may wish to accept the Scottish Government's view that the operation of the instrument will not be affected, as the description of the subject matter is intended only to be descriptive rather than definitive of the offence. Nevertheless, the committee may consider that it is undesirable for there to be an inconsistency in the approach to describing identical subject matter, or for that description to be inaccurate, particularly in the context of describing conduct which amounts to an offence. Does the committee therefore agree to draw the instrument to the attention of the Parliament under reporting ground H, as the explanation of the specified provisions in Schedule 3 of the instrument could have been clearer? John, before we do, yes.
We do, I agree with that recommendation, but I don't accept the government's view that it's unimportant. I think this declaring an interest, tenuous interest as a food producer, I think this instrument, if it was left to stand as it is, as the government sort of tacitly suggests, will only be unhelpful to the food industry, will put doubt into the minds of those who read these instruments and put confusion in. And I think if we're making an instrument, we should just do it properly from the outset. Otherwise it will cost the industry having to go to lawyers, etc., because they won't understand it. So I just think let's do it properly when we're here.
Comments, or are we content to draw it to the committee's attention?
Content.
Thank you. A further point has been raised on this instrument. Regulation 2.3 and 2.4 of the instrument declare that references to Regulation EC number 1331/2008 are to be of ambulatory effect, but Regulation EC number 1331/2008 is not in fact referred to in the instrument. Now, the committee may accept that this error will have no detrimental effect on the operation of the instrument, and may wish to note that the Scottish Government has undertaken to remove this erroneous reference the next time the regulations are amended. Does the committee, however, agree to draw the instrument to the attention of the Parliament under the general reporting ground in relation to this drafting error?
Agree.
Thank you. No points have been raised by our legal advisors on the Town and Country Planning Marine Fish Farming Scotland Regulations 2013, SSI 2013-277. Is the committee content with that instrument, please? Thank you. Agenda item 3, instruments not subject to parliamentary procedure. No points have been raised by our legal advisors on the Marine Scotland Act 2010, Commencement number 3 and Consequential Provisions Order 2013, SSI 2013-276. Is the committee content with that instrument, please?
Content.
Thank you. Agenda item 4 is the Regulatory Reform Scotland Bill. This item of business as consideration of the Scottish Government's response to the committee's Stage 1 report on the Regulatory Reform Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Do members have any comments, or are we content to note the response and reconsider the bill after Stage 2, which undoubtedly we will, because clearly there are amendments to come? Mike.
Yes, that we welcome this Scottish Government's response.
Very happy to do so, if members are content with that. Are members content? Thank you very much indeed. Okay, that completes agenda item 4, and I'm now in a position to move us into private.